Okay, welcome everybody. The class before reading week. Any questions, issues, anything want to talk about? I will be in my office 227 from 2:30 to 3:30 today, if anybody wants to start talking about papers. Is it desirable or undesirable if I put together a list over reading week of 10 paper ideas, if people are fishing for paper ideas?
I think you do have some support on that one.
Okay. Well, if I can get it to more than 10, if I can get it to 20, I will. But I'll go through the materials and I'll post it on the blog. There's no reason you should be wanting to see more of me, but I believe that by the end of today, all of the talks will be up on the blog so that you can review them at your heart's content for whatever conceivable reason you might want to do that. So I called an audible this week. Instead of talking about delivery systems, once I got through on the weekend about 10 slides reviewing last week's class, realized that what I had done intentionally was create a cliffhanger and then go over to you, Alphonse. Here's a lot of room for papers and your thoughts, but there was a lot more that could be done in terms of where the area of consumer contracts in video games is going, and it felt incomplete to me to not do that. So hopefully in doing this talk, I'm not taking away from your papers, but adding additional ammunition to them. So where are we in the course? First part of the course, as we know, was about creating and establishing the notion of a right to create and understanding the constraining power of copyright, emphasize power both as a positive and as a constraint. The second part of the course, which we are beginning to close, is about connecting and the means of connecting, and most importantly, about the notion of creation as connecting, as a connection. And to get there properly, we start seeing that it is connections that result in the act of creation, which then creates further connections. And it's this endless cycle. And it's the second law of thermodynamics. So everything simply moves towards greater entropy, and that's arguably, in a creative sense, a good thing. And we'll actually, in a weird way, get to the end of that thought right at the very end of this talk. And then the other kind of key idea to try and establish is that creation is the merger point of a connected network. And perhaps most important of all, that video games themselves are the merger of creativity and connection. from two vantage points: the creator of the game and the developer of the game, and the player, who themselves are a creator and a developer in their own right. So video games are the perfect metaphor for the world of digital connection which we live in. And all of that takes us to notions of a post-intellectual property world and getting to where we are, whether the dominance of contracts and consumer contracts means that we are already in that post-intellectual property world. And in that context, we talked about different kinds of restraints. The right to resell digital content. The Redigi case, which is continuing in the States, and we heard from Jez Pirwal about how the European Union is more open to ensuring the right to resell digital product. We talked about transferability by will and after death of your iTunes account and digital content, very similar. And the effect of end user license agreements in terms of service, in terms of contracting out of copyright law, and contracting out, in fact, of other fundamental notions like free speech and free expression, which we'll get to. Suggested that there was this interesting symmetry where creation goes with copyright law and connecting goes with contract law. And I want to add another thought to that. And it's to get you focused on the notion of constraint versus restraint. And in my view, the difference is the difference between coercion and control. These are just the most basic definitions, but to constrain is to restrict the scope. To restrain is to prevent something and to keep something under control. So where this goes is kind of obvious. The pattern gets extended. Creation goes with copyright law, which goes with constraints. So copyright law is a societal modality, a government-originated modality that steers, that conceptually steers and creates constraints, like them or not, agree with them or not, on creativity, on users, and allows freedoms in favor of creators and users. But it steers in a somewhat subliminal way the entire system. Connection, which requires more than one person, goes with contract law. And contract law quite literally creates restraints. It's not coercive as much as it's controlling. I just want to pause for a second and get you to think of the logic of that. And wonder whether it's a little bit upside down? Why would the harsher restraint have emerged in this context under contract law, and the less harsh, more subliminal, and in some ways more difficult to deal with, constraints emerged in IP law? It's logical when you think about it from a public policy standpoint. When you look at its precise applications, which is what we were talking about last class and we're going to talk about this class, it starts perhaps feeling a bit upside down for you to decide.
Because freedom of contract allows the parties to agree to whatever they please, so hence the harshness seems more permissible, I guess.
Exactly. Freedom of contract is so central that you get to contract out. And the question we were asking last week, and the question we'll continue to ask today, is in this context, with these kinds of contracts, and these kinds of users, and these particular circumstances, is that right? Now, is it right if I, as hopefully all of you will one day do if you haven't already, gone and to a bank, received a mortgage, read through the fine print, had to go for independent legal advice, had to pay for your independent legal advice, and then get to worry for the next 20 years about whether you get to pay off the mortgage? But the contract is something you spend a considerable amount of time on.
So I think I see where you're going with this. So when you're looking at things like end-user license agreements and other terms of use, to what extent are we actually exercising a freedom of contract, right? Like we're basically, you're saying that we're being restrained by the companies that we're maybe contracting with in terms of agreeing to a EULA. But
Yeah.
we don't have the same freedom of contract realistically.
Well, I'm saying that I'm putting to you, for you to say and decide, that contract law, which makes a whole lot of sense in a whole lot of contexts, starts to tolerate unfairnesses in this particular context. Perhaps. Again, there's different ways of debating it, but I'm going to come back shortly to how contract law works, because you have driven me to look up my law school textbooks from 30 blank years ago and look at first-year contracts again. And I will share with you what I found. But before we go there, want to talk about what's missing. It's a little weird is that when these slides go up here, they are somehow transmuted a little bit differently from the wider slides. So I'm going to have to figure that out because I had warning and notice on the same line. I'm being too aesthetically concerned here. But the point of the last talk, and I should have had this slide, and I've now inserted this slide in that talk, is that was really dense material directly taken from end-user license agreements in cases, and that was the point. The point was to show how dense, repetitive, difficult to follow, and uncoordinated these contracts are, and how different they are from each other. And also to make a subtler point. I don't want to say that those were all of the cases, but those really were very close to all of the cases that really, it was hard to get 10 cases. And a lot of those cases, as you know, were unresolved. So that's interesting. All of which leads to the problem, the problem with drafting. And it's not this in the summer. Dogs on sidewalk only. Well, where do the humans go? The problem with drafting and the problem with not having things standardized and everything being a little different from everything else is that you get the dogs on sidewalk only problem. So hard.
Well, I was just going to ask, when you mentioned how little cases there are on the subject, it seems like, especially with contract being between a business and the consumer, especially in this case, perhaps, it might be fair to say that the law is there to give people to increase the percentage that people will follow what they've agreed, whether or not you actually end up taking things to court, or whether or not you push things all the way to the end. It's almost like by getting people to agree to this, that they're now less likely to do the stuff you don't want them to do.
Well, it's entirely reasonable for you to suggest, as I think you are, well, what's the big deal? If those are all the cases, then why are we talking about this for 2 talks? What's the significance of that? It's obviously not really a problem. So we'll see whether I convince you of 2 things, or whether you convince yourselves more than me convincing you, whether you convince yourself of 2 things by the end of this talk. The first is, if it's unfair, then there's a problem. And the second is, what would happen? What bad would happen if these contracts didn't exist? Are they necessary? And can you convince yourself that perhaps they're not necessary? And if they're not necessary, then where does that take you? Andrew?
Maybe there's something to be said for the fact that we're in a Canadian legal system, but the U.S. legal system is the giant next door, just to our south, and they have much more. I mean, if you win a tort case against somebody, you can win a whole lot of money. So maybe things like having these contracts that are somewhat boilerplate, somewhat customized, is almost just a preventative step to keep, if they didn't have these contracts, could you have individual consumers, could you have groups of consumers trying to go after the developers and the manufacturing companies over possibly frivolous things for large amounts of money?
Well, let's try and take that on directly. But the counterbalance to that is what Zohar said, which is, hey, but there aren't very many cases. If it was that sort of semi-trolling activity, and I'm in no way pretending that doesn't exist elsewhere. It clearly exists elsewhere in the IP universe. But gamers are pure-hearted and amazingly wonderful. And so it doesn't seem to come up. Perhaps there's another explanation. Perhaps it's the lack of the general economic state of the average 15 to 30-year-old gamer. But generally speaking, gamers are there to I think this is fair to say, generally gamers are there to game, not to troll. It does happen. We saw a case last week where a gamer sued a gold farming company. So it wasn't Blizzard who was suing the gold farming company, it was the gamer suing the gold farming company for interfering with their game. Now, I have a hard time characterizing that as a trolling activity, but it does go, Andrew, to your point. So it does happen, but that's 1 of 10 cases, and there are only 10 cases, or if you really look hard, there's 15.
And maybe it's not the, pure-hearted gamers, but maybe it's, we've talked about examples where it's some other smaller groups of people, maybe smaller organizations that are trying to go in and do mods, or possibly
Right.
do the mods and redistribute them or sell them. You can see maybe less pure-hearted groups of
Yeah.
individuals that are.
And so we need to look at whether, at the end of this, you need to decide whether developers can protect themselves adequately without these contracts. Because your argument, not incorrectly, is, yeah, these contracts may not be entirely comfortable legally. They may be a little harsh, they may be a little unfair, most people don't sign them, but there is a purpose in a minority of situations. So let's see if you feel that way at the end of the talk. Because one of the places that I suggest may be possible is that there's no particular protection. There's no particular additional protection that comes to the developer from these contracts. That may or may not be right, but it is hopefully at least a viable question. As lawyers, we always feel better with the belt and suspenders approach. But the truth is your pants will stay up if you just have one of the two. So, we know all this, but just want to quickly focus on copyright being more serious, having more serious defenses, resulting in injunctions, fines, and being statutory in nature. Contract law, in many ways, being less serious. That comes out more in the damages assessment. It is entirely possible, and I just want to remind you of this and see how you would feel about this. It's entirely possible for an end user license agreement to have a liquidated damages clause and to have an injunction permission clause. It's generally not done because that might trigger the consumer revolution. But do think about that. Think about the fact that it's not done. Think about the fact that it could be done. And think about kind of where contracts sit as that kind of additional belt or suspenders. And then we talked a little bit about the cases establishing some notion of consumer and user rights. I'm just going to hit the door here. And then all of the things we talked about, it's the companies that draft, the click wrap fiction, we're all signing it, we're not reading. What increasingly feels bizarre, at least to me, the lack of standardization of these contracts. Where are the industry associations? And then just introducing something that we'll talk about in more detail. All of those 10 cases had multiple causes of action. And we're going to look more deeply at what that means. Those cases weren't EULA terms of service cases only. They weren't contract cases only. And so one of the things for today is to actually break down and look at empirically what got decided and what was at issue and what the causes of action were and what the alternatives were.
No, when you said that, you want us to look at why they're not including those liquidated damages clauses and injunctions and stuff. So, this, my understanding is they're not including it because copyright in the background already has this statutory, there's those things are available through copyright, so they don't want to bring attention to them in the contract. If I kind of understand you pushing this this notion maybe that a standard contract or would be better for users, but if the standard contract had these onerous, liabilities onto the consumer, but they weren't brought to the attention of the consumer because they were in the background from legislation, then the consumer might be actually at a disadvantage by having to have an obligation to know the law, as opposed to just reading the contract that's in front of them.
Well, you're saying that those liabilities are already there. And in fact, you're right, they are already there. So whether the consumer knows the law, and we are all deemed to know the law, not just those of us at law school, I don't know that changes the situation legally. On the other part of your question, yes, it seems like a fair guess that the video game companies are being strategic in deciding not to include liquidated damages and injunction clauses. That's precisely the point. So they know what the larger envelope is. And they're choosing where to belt and suspend themselves. And the question for the day is, do they need to do that? So the question for the day is the morality of this. The morality of the whole situation, and I'm going to try and get you additionally focused on the notion of contracting out. Because you start contracting out, as a gamer, a whole bunch of things, not just your copyright rights, but you start contracting out a certain freedom of expression rights and freedom of speech rights. I'm going to try and show you fairly graphically how that works. And when we get to the section on minors, I'm going to do a case study of a really difficult one, but that's in a future week. And we haven't even talked about privacy yet, and what you're contracting into and out of there. And that is a future week, but that's also very much part of, have you read a privacy policy recently? Should it be called a privacy policy? Should it perhaps be called a non-privacy policy? And what if you're actually not reading them, which most of us aren't? Anyways, we'll touch on that to some degree. Okay, so where this takes us is, just want you to see the flow. And I'm sorry about my lousy graphics. I wish I could figure out how to do a nice table that scrolls down properly and has down arrows. You start with copyright, it's a constraint. But there's some user rights. There's reverse engineering, there's fair use, there's some kinds of free expression, right to create rights somewhere bundled in there. Boom, we get to the contract. The contract then removes some of all of, part of the user rights. Typically no reverse engineering, often no mods, bunch of other stuff. Also add some rights, often around privacy to the company, and takes away some of yours, which is kind of the other part that we'll be talking about later in the course. And all of that is begetting, if you accept the notion suggested last week, is that even in these contract cases, you're seeing a reemergence, or at least a leaning of the courts towards some form of user rights. And you see that especially in the glider case, right? You can't make the bots, but if someone uses them, that's not going to be a breach of American copyright law. However, we'll come to that a little later in terms of specific reference. Blizzard can still kick you off of World of Warcraft if they can figure out that you're using bots. So we get there. And the deeper question, again, is, so we're moving from constraints to restraints, generally without particular user understanding. And how does that make you feel? The lens of the double standards test. Talked about it a lot. Let's apply it here. Here's the thing that's bugging me, and I'll make this a little personal. How is it that the algorithms that digital media companies have developed allow them to know so much about me with such precision that they are feeding me customized information every time I log on? Google, Facebook, it's customized for you. So you're going to customize all that information at all of that expense for little old me. But you can't modify your contractual terms? That's the one thing that's too hard to do? Really? That's just too hard? But everything else? That's okay? I think they've got the technology. So put that in the double standards test pipe and see what it feels like. And then the simple cheap shot. If you've worked with creators, how many creators could survive the contractual terms that they would impose on others? And again, fairness is the theme. And then there is kind of a really crazy idea which can, I shouldn't say it's crazy, but we're probably a couple of layers away from it. But we may be developing the technology. Is it might be a really interesting world if we moved away from double standards, and that to the degree that I use your stuff, I can't prevent others from using my stuff. So single standard. If you're an absolute reclusive genius and you're absolutely convinced that all your genius comes from within and from nowhere else, then don't use anybody else's stuff and see how well you do. Let's see that world for a minute. So technology in a couple of generations may allow us to get there. Whether we ever implement it, It's a different question. Now, just want to deal with one other question, which Helen Love asked last week, and which, in fact, Andrew asked today. So, don't we need this for the really bad stuff? Don't we need it? You know, it was implied in your question. For that small percentage of situations where there's bad people out there and the game company needs to deal with it. And this is an additional and useful tool. The contract is an additional and useful tool. So, generally speaking, and again, we only have a limited sample of cases. I'll give you some other examples from articles. But the cases tend to relate to commercial threats, not really bad stuff, or quasi-commercial. You know, modding, you can try and characterize it as really bad, but it's definitely at least quasi-commercial. And I'll cite the Davidson case and the iRacing case, as if you read those cases, it's really specific examples where, in essence, it's commercial. The modding cases feel that way. The bot gold mining cases feel a little different. They feel a little more 50-50 because there's at least the notion of protecting the gamer's experience, which doesn't exist in the mod cases. Because the mods are about the gamer's experience. So you can't protect the gamer's experience by going after the mod makers. But with the gold mining cases, you're imbalancing the game, you're affecting gameplay. There's more of an argument, much more of an argument. And there's no way of fully resolving that or reading what's in people's minds, but I'll just, remind you that the in-game dollar case that we talked about, gold farming case, 2007, and then Blizzard introduces buying in-game World of Warcraft items, 2009. So, you could say, no, they were inspired by the gold farmers and realized they needed to do this, or you could wonder, legitimately, did they always know they were going to do this, and they wanted to make sure that they controlled the marketplace. And it always does come back to, if they control the marketplace, they're able to balance the game. So none of this is so simple.
So would you maybe think then that EULAs or terms of service or other contractual pieces were actually appropriate if something falls in the category of really bad stuff? For example, would you want some sort of contract agreement that says, maybe yes, you can mod, but you can't mod in such a way that your mod is going to go into somebody's computer and steal their private information, or it's going to, install spyware or something like that. And if that's something that's acceptable for a contract to prevent really bad stuff from happening, maybe it's just a question of where you're drawing the line as opposed to whether or not you have these things in the first place.
Yes, I accept that there's a utility. My question, and thank you for setting it up so wonderfully, is at the top of the slide. Could you achieve that utility with a short notice? Now, I drafted that. It's highly imperfect, but if there was, you're the law students, if there was a notice that came up, not an end-user license agreement that you're agreeing to, but just a very clear notice that said, look, cheating, illegal or intolerant behavior is not acceptable, and we can do whatever we want in those circumstances, including suing you. How many situations would that deal with?
I think we need more words. I don't know what cheating is. I don't know what intolerant behavior is. And if somebody sues me because I accidentally swore or something, I'd feel upset.
Yes, and you would feel upset, and then you'd have more recourse probably than you do now. I use the old lawyer's trick, and maybe I put it in the wrong place, but those definitions should be in the sole discretion of the company. But they already are. You're in way better shape as a user, we'll come to this, If you're dealing with a notice provision, then the current situation under an end user license agreement. So, you know, I would agree maybe this is still too illiberal, but even your question would tend to show that end user license agreements may be too much. But that actually goes to, or your question I think goes to the more important point. And that's that there's really a more insidious result here. And that insidious result is about censorship. And that what's happening is that in these contracts, not only are you contracting out of your copyright rights, but you're contracting out of your expressive rights. So if you swear, let's go with your example. If you swear and you get kicked off and you've clicked I agree, you've contracted out of saying, no, that was, I'm entitled to my free speech rights if I can apply them to this private context. You're one more step removed, and the company is one more step allowed to censor you. So this has been in the news. Please go on, and I'll go to the case.
I take it you're against a confidentiality agreement because it prevents you from expressing some secret that you've signed and agreed not to divulge. Because that's censorship too. But the world doesn't work without it.
Well, now you're arguing it the other way. So yeah, you can contract out of anything you want. But if it's a confidentiality agreement, you've thought about it. And nobody's making you sign a confidentiality agreement here. These are generally agreements, I think we're all accepting, that people aren't thinking about. Let me come to you in a second, Zohar. But the most notable example is Apple saying, in effect, we will not accept politically based games. Now, maybe that's okay. Maybe that's fine. Maybe it isn't. And that's the question. Given issues of market power, given free expression, you simply contract out. But all of this shows, so there was a statement, there was an original article where somebody from Microsoft was understood to say that sexist talk on Xbox Live will result in a lifetime ban. And then there was a clarification, and you can go to the articles, but there was a clarification that sexist talk won't, but racist talk will. So you start making all of these, parsing out these interesting distinctions, and they're all happening in a purely private sphere. And they're all enforceable under the EULA. And is that okay? And that may be okay. And you say, oh, I'm good. I've contracted out. I understand that this is your world and your universe and your web. And I'm okay with that. And if that's what it means to you, that's fine. But what you cannot escape from, and what I won't allow you to escape from, is acknowledging that this is exactly what's happening. Because this is how it works. Now, if it's okay with you, then you're good to go. It's not okay for everybody. And if you're a developer of a game about insurgents in Syria against the Syrian government, you might feel differently. You might feel a game like that should be played in this world. For you to decide. Questions on this? Okay. So, enough philosophy. Let's go to function. Core point, if you read the cases, if you read the pleadings, and this was actual work I did this week, you will find that every one of the cases, every one of the limited number of cases, had multiple alternative causes of action. Okay, well, that's obvious. Lawyers have a tendency of putting in everything but the kitchen sink. But something really interesting happens when you actually go to the couple of decided cases, because they can be a guide to us on everything else. Well, Davidson, the mod case, B net D. Well, yeah, there was a breach of the EULA found in the terms of service. But way more importantly, there was a breach of the Digital Millennium Copyright Act found. That's where the real teeth of the case was. That was by far the more important finding, because a breach of copyright legislation, as we've discussed, is way more serious than a breach of the contract, and superseded it. In-game dollar, the case was settled, but there were various other things pled: intentional interference with contract, unfair competition, unjust enrichment. There's a gold farming case. MDY, which is the bot case, breach of DMCA found. Blizzard and Marshall, everything but the kitchen sink, but the EULA was just a little part of it. Breach of copyright infringement, circumvention of copyright protection systems in violation of the DMCA, tortious interference with contract. iRacing, copyright infringement found. Zynga, trademark infringement, unfair competition, passing off, intentional interference with contractual relations, consent judgment. Avani and Holland, trademark and trade dress infringements, tortious interference with contractual relations, all found in the default judgment, or at least accepted in the default judgment. The other cases, sorry, I missed a slide. The other cases don't directly apply, but there's nothing in those cases that would contradict what I've put in front of you. So the non-EULA claims are not equally important to the EULA claims. They're more important, and they succeed, which raises the question, at least the question, do we need these consumer contracts? Okay, talked about World of Warcraft. I go to some trouble, just so you know, to find on Wikipedia and elsewhere images that are pre-cleared. But the point was made, hey, the end user license agreements are not that long. Last week, is it really that bad? So from the in-game dollar complaint 2007, total of 16 pages in the appendices. And we'll hand these around. And you can decide for yourself how big the fonts are or aren't. And yes, in the current World of Warcraft agreement, that has been reduced to 15 pages. And here's examples of the fonts. And again, you decide whether you would read them or not. Now let me show you something that's buried in there. I like this one a lot. Termination clauses. You enter into a contract, and we've all clicked I agree on a whole lot of contracts. You thought about the fact that those contracts are still out there, and you're still bound to them? And they don't seem to terminate. Do you know well, you haven't read them, so how do you know if they terminate or not? And I'm not picking on Blizzard or World of Warcraft, it's just for other reasons caused by you. I did read that agreement. And I looked at the termination clause. And it says, you may terminate the license agreement at any time by doing 3 things. Permanently destroying all copies of the game. Okay, maybe that seems reasonable. Removing the game client from your hard drive, that's certainly reasonable. And, so you got to do 1, 2, and 3. And notifying Blizzard of your intention to terminate this license agreement. I would love to know from Blizzard how many of their millions of users who they know aren't playing the game because World of Warcraft game playing has been declining rather precipitously. Well, it has been declining. I don't know that I need to editorialize because I don't know the accuracy of what's been reported. Have notified them of how many of the users who are no longer playing the game have notified Blizzard of their intention to terminate the license agreement. That's an and. So there's no termination until that's done. And of course, I need not take the cheap shot, but I will. Blizzard may terminate this agreement at any time for any reason or no reason. So it's over when they say it's over. It's over when you tell them it's over and you've done a bunch of things. And because nobody's read this, I wonder how many times, or few people have read it, I wonder how many times, I think it's a legitimate thing to wonder about, they've been notified.
Yeah, but even so what? Like, even if you don't notify Blizzard, what happens to nothing?
Simply saying, in a society where you guys are arguing the contract is so important, and you were taught in first-year contracts law how important it is, and the sanctity of contract. You've got hundreds of contracts out there that aren't terminated. If you're good with that, again, for you to decide. If you're good with it, it's the way of the world, it's fine. But know that it's there.
You're seeing this as a negative thing, but it also means that in 3 years when I decide to reevaluate my WoW addiction, I can return to it and I don't have to rebuy the game because I still have a license with them. It's still effective, even 10 years from now.
Fair enough. If obviously, one of the really interesting things, and that's why I was a little ambiguous on it, is this notion that you have to destroy all the copies. Because then you don't have a copy to come back to. And they obviously want you to come back. So, the two together means it's the Hotel California. You can check out but never leave. we've gone through these points, but just, the privacy policy reading level is of a privacy policy requires a college sophomore level of reading. The average US reading level is 8th grade. The next one I find really interesting because it's jujitsu. Microsoft is launching a campaign to attack Google on Gmail privacy. The ads will showcase research that shows that most people don't know that web email providers like Google scan the contents of their email messages to deliver personalized ads to them. Well, if people read their EULAs and their terms of service, they would know. So the whole ad campaign is actually premised on the fact that people aren't reading these things. So it's just a fascinating irony that tends to prove the point. And then I just want to refer to a website called Terms of Service Didn't Read. And if you're looking for whatever purpose, an assessment of different websites' terms of service, they give it to you. It's not, it's done in simple graphic form, but it is an interesting tool, and the fact that it exists is important. So I promised you the common law. And the challenge is that the common law, and you guys have all taken first-year contract, reinforces why these contracts should be enforceable. And I've quoted Anson here from 1882, but I just find it wonderfully fitting. Every expression of a common intention arrived at by the parties is ultimately reducible to question and answer. I just love the fact that do you agree, I agree, is question and answer. It's wonderfully prescient from 1882. But more importantly, and you know this principle, the common law is not concerned with inward and mental assent, but outward and visible signs. So it's the objective test of I agree, not the do you really agree. So yeah, these contracts, that's why these contracts keep getting accepted, despite their click-wrapness, despite the reality that most people aren't reading them. This is why these contracts are upheld by the court over and over again. I refer you to the Rogers case that we talked about. The question you need to ask yourself is whether you're comforted by that. Because when the law gets so divergent with what's really happening, usually there's a change. Usually a denning will emerge. Usually something will happen. So are we in the moment before something happens? And what does that mean? So what happens if there aren't these consumer contracts? What if they disappeared? The question for you to decide, and the question for you to still write your papers on, is does copyright law occupy the field, along with competition and antitrust law, and privacy law, and consumer protection laws, and possibly the development of international law and treaties over the next few years, and other forms of legislation or regulation? And when you go through all of those, is it necessary to have, and some form much better drafted of a notice provision? Do you need end-user license agreements and TOSs? And if you don't need them, is it still okay to have them?
I think we should want them if the alternative is reading the entire Copyright Act and everything we have on the slide. much rather read Blizzard's 16-page EULA. It's just redundant.
Fair enough, except the Copyright Act, as Zohar has pointed out, doesn't go away. And the proof of that is in the pleadings. It's additional. If, hey, you know what? I understand, whether I agree with or not, I understand that if this was all simply private law and there was no government intervention, that preference would be a completely viable preference. But it's not. These things are additive. Nothing's being taken away.
Well, it just seems like, maybe this is obvious, but I mean, we're talking about games, and it seems like the law, what the law does for society is set rules that are supposed to make society flow better for the people in it. And games are setting rules for their users so that they can have the right type of experience and not have the wrong type. And so it seems like you need to educate your users in some way on what they can and can't do so that the environment, the ecosystem that you're building can thrive.
And I'm not disagreeing with you. And the question that I'm putting is, can you do that through a notice? And when we're going to talk about some games later on in this course that create a fully open environment, essentially without rules. And we'll see how that has worked out. And that'll help answer the question. Just want to, because this is very fresh, want to refer you to a wonderful presentation Nick Grossman did on what the principles of regulation in the digital network age might be. Did it at Princeton, I believe, last week. It's very fresh. There's both video and slides, but it really goes to this question of, I'm not comfortable with regulation. So, you may or may not be happy with where he's going, but I'll let you judge, because he says some interesting things about if there is going to be regulation, how different the principles need to be and why they need to be different. And then very quickly, the other things that are happening, well, we saw what happened with Instagram's revised terms of use, so there's market uprising and the free market effects. And then there's this interesting thing where Sony and perhaps Microsoft, it's not clear, are showing interest, and we know Sony because they filed the patent application, doesn't mean they're going to do it, but they've devised an internet-free method for blocking used game sales. So they're creating a radio frequency recognition piece on the disk and on the console, and they're mated to each other. And once they're mated, we're not talking about a DRM system, we're talking about something that's physically in the disk, and that's it. And if it gets implemented, there's no used game sales. So there may be technological ways of doing this outside the EULA. And then, just to end, the other possibility. This goes to government and legislation. Got to point out, it was a 336-word bill in California, introduced 2 weeks ago, last week, that would purport, it's not going to go anywhere, but would require that all privacy policies be no more than 100 words. So we're starting to see legislators get interested. If you go to the blog site, there's, and you're interested in writing papers in this area, I've just given you a whole bunch of readings that are available out there if this is something you want to get into. Next week, 2 weeks from now, after reading week, wheelbarrows to holodecks. So everything about delivery and the future of games, and riffing off of Tyler's very first post to the blog. Something to leave you thinking about. Go to this article if you want to have your mind blown over the next 2 weeks, or you don't want to sleep. Are you living in a computer simulation? This is a serious piece by Nick Bostrom of the Faculty of Philosophy at Oxford, and it basically argues that we are quite possibly in a computer game created by future generations of man, hundreds, maybe thousands of years in the future, and cites the notion that with computer progress going the way it is, it's not hard at all to conceive that at a certain point the horsepower will be there to simulate every single thing, including every single thought of every single purported human. It's a real Matrix piece, but it's a serious piece, and it has resulted in some fairly serious academic thought and physicists trying to devise tests as to whether we live in the Matrix or not. And those tests are about, if this is a computer simulation, of course our future selves might have come up with all sorts of technology that we can't imagine, there still would be, the world would still be pixelated in some way. So you now have scientists trying to figure out whether the real world is pixelated. Because there'd be a point beyond which you couldn't resolve, or it would become fuzzy. I couldn't find the article. I didn't look very hard for it, but I did see an article saying that 2 academic groups had studied this question, and one group had found that the world is smooth and therefore we are not in a simulation, and the other group has found evidence that tends to suggest that the world is pixelated and we are in a simulation. As my colleague Kimberly Vole said to me this morning, what does it matter if it feels real? It is real. So I hope you have a really very real break. Take care. And we are now going to go to our speaker.